And you're a judge. You claim you're a judge. You don't know law. You don't know law. Nonsense. Where is the family address? Where is it? Which law gave you the right to go to my family address?
You see that judgment? It is airtight. There's no judgment that cannot face appeal. But the truth is that that judgment will stand any appeal, even any appeal before God. That judgment will stand. I have the job. I will send it on. I will paste that. I will paste that judgment on this on the comment section. I have gone through the judgment. I read it. That judgment is airtight. Justice Omotosho did a very thorough job.
All right. Stay on this sentencing of Nnamdi Kanu by Justice Omotosho of Federal High Court, ACJA, to life imprisonment. You know, there is this argument, there is this divided opinion about whether the trial was fair or not. Some people say that it's fair. Many say that it's not. So, I'm not a lawyer, you understand? But see, this world now is a global village. There is no information you cannot get. I saw somebody making a video that the trial, a lawyer, making a video that the trial wasn't fair. You know, he pointed out some section of Constitution. Then, you know, before I say something, I try to dig deep into that to find out whether, you know, people can just come online and say anything without it being true. So you don't just start sharing whatever you see online without finding out if that thing is actually true or not. So, like I said, this video might actually be a little bit longer, but it's worth it. I think you have to follow me up. Let's go into the detail and find out if actually Justice Omotosho did a nice job or not. So this is what I find out under the administration of Criminal Justice Act in Nigeria. Then this is section 349 6 2015 restates this condition when it stipulates that where the defendant chooses to represent himself, the court shall inform him of all the rights under the Constitution of the Federal Republic of Nigeria 1999 under this Act, and indicate, that is B, indicate the fact of having informed the defendant on the record. But a defendant charged with a capital offense or an offense punishable with life imprisonment shall not be allowed to represent and defend himself. However, the condition is not expressed contained in the Constitution of Federal Republic of Nigeria, but this has been the line of judicial thought for a while. In the case of Josiah and State, the appellant was charged with multiple capital offense of murder and armed robbery. He was not represented by counsel. The Supreme Court overturned the decision. Similarly, in Okotobo v. State, the court held that the failure to provide an accused with a legal practitioner when he is standing trial for a capital offense will render the trial a nullity. So, this is what Supreme Court ruled. And you know that anything on Supreme Court rule is final. Then After seeing this, then I dive more into the detail. Then I ask, can accused person be allowed by judge to represent himself under terrorism charges in Nigeria law? Under Nigeria law, this is the answer I got. Under Nigeria law, the general rule in that an accused person dey represent sorry, under Nigeria law, the general rule is that an accused person may represent themselves, defend in person rather than using a lawyer. For example, 1999 Constitution of Federal Republic of Nigeria as amended provide a section 36(6)(c) that every person who is charged with a criminal offence shall be entitled to defend himself in person or by legal practitioner of his own choice. Administration of Criminal Justice Act 2015 applied in federal courts in a state that adopt it. State in a section of 267, that is section 267, that defendant is entitled to conduct their case in person or by legal practitioner with exception. However, there are important restrictions when the offences is very serious. In particular offences carrying the death penalty or life imprisonment or classified as capital offence. For instance, the ACJA stipulates in section 349(6)(b), that was the section I read that time, that where a defendant chooses to represent themselves, a defendant charged with a capital offence or an offence punishable with life imprisonment shall not be allowed to represent himself, represent and defend himself. The judicial commentary explained that for offence punishable with death or life imprisonment, the court required the accused to be represented by counsel, or else the accused, after being informed of the risk, elects to defend himself. Then, application to terrorism charges. In Nigeria, terrorism related offences are generally very serious, often punishable. I will be dropping this thing so that it won't take so much long. The summary, I will be pointing out some of the important detail in what I find out. So the summary, generally, an accused person in Nigeria has the right to represent themselves, but when the offence is capital offence or punishable with life imprisonment, which is likely for many terrorism offence, the law restricts self-representation. The court must ensure counsel is provided and must inform the accused of the risk. So that is the summary of that verse. Then I go on to continue to dig deep. Then I ask again, does judge inform the accused person who want to represent himself on the terrorism charges to seek a lawyer? They say yes. Under Nigeria law, a judge must inform an accused person charged with terrorism or any serious offence that they need a lawyer. So it continues. Then I go again, I continue. Then on 6, Self-representation is remitted in a capital or life imprisonment offense. That is what he said. Then, okay, what the judge must do in a terrorism cases. A judge will do the following: ask the accused if they have a lawyer. If not, urge them st- urge them. If not, urge them strongly to get one. Explain the seriousness of the charges. Offer to appoint a lawyer through legal aid or duty counsel. Refuse self-representation if the charges carry life imprisonment or death. So, can the judge allow the accused to defend himself anyway? Usually, no, not in terrorism cases. So, all these things I continue wondering, does even Omotosho even insist that Nnamdi Kanu must have a lawyer? Because of some people who are saying that it was a fair trial. Does he mean that Omotosho don't know this part of the law? Or did he do that or we didn't see? I don't know why in Nigeria a high profile cases like this are not being televised by media, except when the judgment are ready. Because I know in South Africa, high profile cases are being televised, even starting from the beginning to the end. What are they scared of? Okay, I continue. Then, okay, the final answer: yes, a Nigerian judge must inform and warn the accused person facing terrorism charges to get a lawyer. And under ACJA, the judge normally cannot allow the accused to represent himself because terrorism charges often carry life imprisonment. So I continue. I continue. Now I ask again, what if the person was having a lawyer and later chooses to represent himself during the trial? Is it allowed? In Nigeria, or an accused person can decide to do the general rule in Nigeria. This is say, but for terrorism and other very serious offenses, the rule, okay, but for terrorism and other very serious offense, the rule changes. Do you get it? Most terrorism charges under Terrorism Prevention Act carry life imprisonment and extremely long sentence. Under the Administration of Criminal Justice 2015 section, this is a defendant charged with a capital offence or an offence punishable with life imprisonment shall not be allowed to defend himself. This means if the accused is charged with terrorism punishable by life imprisonment, no, he cannot fire his lawyer and represent himself. The judges must ensure that he continue to have a legal representation. Even if he insists, the court may appoint another lawyer for him or order the same lawyer to continue because the law does not allow the court to leave him unrepresented. So now, what the judge will do if the accused tries to take over the case, ask why he wants to dismiss his lawyer, explain the seriousness of the charges, inform him that terrorism is a serious offense during legal representation, refuse representation if the charges carry life imprisonment, ensure a lawyer remain on record, legal aid or no lawyer. The judge cannot allow self-representation because it would violate Section 349 of Administration of Criminal Justice Act. Final answer. For the terrorism cases punishable by life imprisonment or death, no, the accused cannot suddenly drop his lawyer and represent himself. The judge must ensure he remain legally represented. So this thing now come to the argument whether the judge did all this. It shows that if this case actually get to Supreme Court, it may actually discharge based on Administration of Criminal Justice Act 2015. So I don't get it. Like I said, I don't know if all these things were played out. But to our knowledge and what we normally see online, like a sneak pictures video, we never see something like this. So I leave people to judge, and I'll be putting the whole detail in a comment section. You can find it there and read the whole thing. So thank you for watching.